For our first lecture, we will have a very good lecture on sexual harassment. Our esteemed and very honored to be introducing him once again is a lawyer, a certified public accountant. He passed the CPA licensure exam in 1984 and placed 18th in the bar exams, and the CPA exams. Passed the bar exams in 1989. He is a professor of the College of Law at the University of the Cordilleras from 1989 to 2018. He is currently a professor of the College of Law at the University of Baguio. He also teaches taxation law, commercial law, criminal, and civil law. He is also a senior partner of the Bandonill Law Office. He is also affiliated with the Felix Mining Corporation Incorporated, the Hamada Publishing Company Incorporated, Diamond Rural Bank, Torrent Development Corporation, Pizza Volante Enterprises, the Lemon Grove Group of Companies, the Allied Hospital Supplies International Corporation. He is also the proprietor and owner of El Domicilio Bed and Board. He is a columnist of our very own Baguio Midland Courier, and his column is named Circumstantially Factual. He is a legal luminary of the Bombo Radio Philippines here in Baguio City, and of course, a loving husband to Dr. Anjo and Bandonill, and a proud father to Dr. Iris Bandonill and Israel Bandonill. He is also my kumpare. So now tonight, let us now give a big round of virtual applause to Attorney Guillermo Bandonill Jr. Take it away, Doc. Ay, sir. Ano ba yan, Doc? Sir, Attorney.
Good evening. Thank you, Dr. Sheila, for that introduction. I just want to share my screen before I start my lecture. Share screen. Can please be patient. I cannot. Please accept. The host disabled.
For a while, attorney.
Okay, please.
You can try again, attorney po.
Okay, there. Doc DJ, wala pa? I have already shared my screen, wala pa? You have not yet accepted it.
Attorney, you have shared it already, sir. Apo. Try niyo pong i-share ulit po. Tapos you go to your PowerPoint. Are you in PowerPoint po?
Yes.
Share it again, attorney. Tapos i-try niyo. Click on your PowerPoint. Yung PowerPoint po.
There.
Okay po, attorney.
Okay na. Can you see my screens? Can you see my PowerPoint now?
Yes,
okay.
Attorney. Here po.
I can see it already.
Good evening, everybody. There are several crimes that penalizes sexual offenders in our country. We call them crimes against chastity. We have the revised penal code. We have the Republic Act number 11313, or the so-called Safe Spaces Act, or in the local parlance, the Anti-Bastos Law. We also have Republic Act number 7610, which provides special protection to children against sexual offenders. And of course, there is the popularly known Republic Act number 9262 or the VAUSI law, the Violence Against Women and Their Children. But since the topic that was assigned to me is sexual harassment in the workplace, I will confine my discussion to sexual harassment in the workplace. And the primary law that governs sexual harassment in the workplace is Republic Act number 7877, entitled An Act Declaring Sexual Harassment Unlawful in the Employment, Education, or Training Environment and for other purposes. Now, how does this law define sexual harassment? Section 1 of Republic Act number 7877 defines sexual harassment as an act when an employer, teacher, or any person who has authority, influence, or moral ascendancy over another demands, requests, or otherwise requires any sexual favor from the latter, regardless of whether the demand, request, or requirement for submission is accepted by the object of said act. Take note that the sexual harassment is confined to the persons enumerated, and these are employer, teacher, or any person who has authority. But let us limit our discussion on the employer because we are talking about sexual harassment in the workplace. Okay. So, based on the definition of sexual harassment, we can look into the requisites of when a person may be charged for sexual harassment. The first requisite is the offender is a person who has moral ascendancy or authority over another. Okay, take note. It does not say that a person must have superiority or superior position over another before there can be sexual harassment. Kasi the most often asked question is, Sir, is it necessary that before a person may be charged for sexual harassment, the offender must have a higher position than the victim? Not necessarily. That's why the law uses the word moral ascendancy or authority. What do we mean by moral ascendancy or authority? It simply means that one person has the ability to influence the other. It simply means that another person has the ability to impose consequences on another on the refusal of the other to comply with a request. So it's not necessary that before a person may be charged with sexual harassment, he must be of superior authority or of higher position than the other. Let me give you an example. During the time of the pandemic, the Department of Labor and Employment required all factories and all establishments to have services to ferry their workers from their residence to the workplace. This is because there was a shutdown and there were no public transportations that were available. So in an actual case that happened, a factory hired a driver. The driver's duty was to ferry or to transport the supervisors and the managers of the company from their residences to the factory. Okay? So the driver who was hired had this infatuation with one of the managers. So every time the manager would ride this jeepney, sinasabi niya, "Oh, madam, ang ganda niyo po. Pwede po ba ihatid ko kayo sa bahay ninyo? Ma'am, pwede ho bang dumalo sa bahay ninyo?" He was saying that. So the manager felt very insulted and she felt very uncomfortable that she filed a case of sexual harassment against the driver. What was the defense of the driver? He said that under Republic Act number 7877, it is necessary that before a person may be charged with sexual harassment, he must have a superior position or a higher position than the victim. And what did the court say? The court said that it is not necessary that before a person may be charged liable for sexual offense under the Sexual Harassment Act, he must have a superiority of position or a superiority or position that is higher than the victim. It is enough that he has a moral ascendancy or authority over another. And let us repeat, what do we mean by moral ascendancy or authority? It does not pertain to the hierarchy of position. It simply means that there is the ability of one person to influence the other, or there is the ability of one person to impose consequences on the refusal of another person to comply with the request. So in this particular situation, sabi ng Supreme Court na maski driver ka, you have moral ascendancy over the manager because your threat is kung hindi ka padadalawin sa bahay mo, hindi mo siya ihahatid sa bahay niya. No? So that is enough, said the Supreme Court, to establish that there is authority or moral ascendancy over another. Okay. So more specifically, who are the persons who may be charged for sexual harassment, or who are the persons who have moral ascendancy over another? Okay. So I have enumerated them. Examples of persons who may have moral ascendancy over another. These are, number 1, the employer. Number 2, the employee. Number 3, manager or supervisor, agent of the employer, teacher, instructor or professor, coach or trainer, any person who directs or induces another to commit sexual harassment. Next slide. The gravamen of the offense of sexual harassment is that a person has authority or moral ascendancy over another in such a manner that due to such authority or moral ascendancy, he is placed in a position to ask a sexual favor from another. Again, the essence of sexual harassment is it is the existence of authority or moral ascendancy. Without authority or moral ascendancy, there can be no sexual harassment. Okay? Let's take the case of Christy Ramos versus Lexton May. We of course know who is Christy Ramos. Christy Ramos is the daughter of the late President Fidel Ramos. Lexton May is one of the members of the ASCAL soccer team of the Philippines. In the late 2017, there was an interest in soccer because the ASCAL team placed the Philippine soccer team on the Asian map. Okay? During the Asian tournament in 2017, the Philippine team, the soccer Philippine team, won over the team of Vietnam, which is a favorite in the tournament. And because of their victory over that, Lexton May was so happy that he went over to the stage and embraced Christy Ramos. Christy Ramos before was the chairman of the Philippine Olympic Committee. Christy Ramos felt offended and she filed a case of sexual harassment against Lexton May, okay, one of the soccer players. And Lexton May pleaded innocent and he said that I cannot be charged with sexual harassment because we have no relationship with Christy Ramos. And what did the Supreme Court say? The Supreme Court said that Lexton May is correct. There is no sexual harassment. Why? Because Christy Ramos, who is the president of the Philippine Olympic Committee, is not in any way related with the soccer team of the Philippines, and therefore she does not have any authority or moral ascendancy over Lexton May. It could be, said the Supreme Court, that you can charge him for unjust vexation or acts of lasciviousness, but not sexual harassment. Because as we have said earlier, the gravamen of the offense of sexual harassment is the existence of authority or moral ascendancy, without which there can be no sexual harassment. Okay? Now, remember also that sexual harassment has nothing to do with sex, sexuality, or gender preference. What do we mean by this? We simply mean by this that a person can be charged for sexual harassment even if the victim is of the same sex or of different sex. It does not matter. So is it possible, you may ask, that a woman may be charged for sexual harassment if the person she sexually harassed is also a woman? Or conversely speaking, can a man be charged for sexual harassment if the person he victimized is also a male person? Yes, because sexual harassment is not concerned with sex, sexuality, or gender preference. In fact, there had already been several decided cases about this matter. The leading case about this is the case of Gretchen Pulido versus ABS-CBN. Gretchen Pulido is the announcer or the host or the MC of TV Patrol in the portion, what's the portion? That portion yung tungkol sa mga artista, Star Patrol, no? Now, during the time that she was working with ABS-CBN, one of the executives of ABS-CBN took fancy on her. And this executive was an LGBT. She was a female, no? She fell in love, or she had an infatuation with Gretchen Pulido that she wanted Gretchen Pulido to be her Thursday girl. Yun ang tawag niya, no? So probably she already had Monday girl, Tuesday girl, Wednesday girl, and she wanted Gretchen Pulido specifically to be her Thursday girl. And she said that Gretchen Pulido must go to her house every Thursday and entertain her just for them to talk. No? Ganun lang, mag-uusap lang sila. And if she did not want, she said, I'm going to remove you from that Star Patrol segment and put you in another segment if you do not consent to my request. Sabi niya, no? So what did Gretchen Pulido do? She filed a case of sexual harassment against the executive who wanted her to be her Thursday girl. And what was the defense of this executive? She said, you will be charged. Okay. And the executive said, the defense of the executive was that, according to her, she cannot be charged with sexual harassment in the workplace because there can be no sexual harassment if the aggressor and the victim belong to both sexes, to the same sexes. And what did the court say? Of course, this was highly publicized. And during the initial stages of the case, the prosecutor who was investigating the case believed the executive of ABS-CBN and dismissed the case. It was his opinion, the prosecutor's opinion, that there can be no sexual harassment if both the victim and the aggressor are female. If both of them belong to the same sexes, then there can be no sexual harassment. That was his opinion. Is he correct? The Supreme Court said that you are not correct. Hindi pwede, no? Even if both the victim and the aggressor are of the same sex or are leaning to the same sexuality or are of the same gender preference, there can be sexual harassment. Okay? Because the essence of sexual harassment is to prevent somebody from influencing another with the exchange, with the thought that there will be an exchange of favors. Okay? So that being said, let's go to the next slide. So let's give an example of when a person has moral ascendancy over another. Let's take up the case of LBC Express versus Monica C. Palco. Monica C. Palco is a probationary employee of LBC Express. A person was assigned as her supervisor to train her during her probationary period. And this person who was assigned to train her, a supervisor, fell in love with her. No? Linigawan siya. No? So there were days na pag pumapasok si Monica C. Palco ay tinitignan niya ng medyo pangiti-ngiti, binibigyan niya ng mga chocolates, he was given roses, and Monica C. Palco felt uncomfortable. And what did she do? She stopped reporting for work. She stopped reporting for work and she filed an action for illegal dismissal against LBC Express. Kaya LBC Express ang party dito sa kasong ito. Because it was against the LBC Express that Monica C. Palco filed a case against. Sabi ng LBC Express, you resigned. You left. Umalis ka. Wala naman kaming ginagawa. No? But Monica C. Palco said that it was a constructive dismissal because the atmosphere of the place of her work was no longer conducive to a harmonious environment of work. Sabi niya, paano naman ako hindi aalis? Every time I go to my place of work, nandyan yung supervisor ko, tinitignan niya ako ng masama, pangiti-ngiti, he's always sneering, he's always giving me roses, he's always giving me chocolates, and he's even making advances. And the Supreme Court had the occasion to discuss what constitutes sexual harassment in the workplace. And in this particular case, the Supreme Court said that yes, there is sexual harassment because a supervisor who has moral ascendancy over her, siya ang nagte-train sa kanya has demonstrated acts that tend to make Monica C. Palco uncomfortable. There were sexual intonations in the manner by which she was being treated by her supervisor. And therefore, sabi ng Supreme Court, since the atmosphere at work is already so strained, hindi na maganda yung relationship, it was justified that Monica C. Palco filed her resignation, but that resignation should not be taken against her because it is tantamount to constructive dismissal. Okay? So that is the example of case when another person has moral ascendancy over another. Okay? The second requisite of sexual harassment is A. The sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of said individual. Halimbawa, sasabihin mo, kung hindi mo ako hahalikan, hindi ko i-renew yung kontrata mo. If you're not going to go out on a date with me, then I'm not going to hire you. Or in granting said individual favorable compensation, terms, conditions, promotions, or privileges. Sometimes employees covet for promotion and they go to their bosses and talk to them and say, boss, kailan mo ako ipopromote? Okay, ipopromote kita, basta mag-date tayo. No, that is what is meant by that. Or refusal to grant sexual favor resulting in limiting, segregating, or classifying the employee which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. Kagaya nung Monica Palco na binigay natin na example. Because of sexual favors or sexual intonations from his supervisor, she was forced to resign. Or there are instances when an employee is sought to be transferred because they refuse to give in to the demand of their bosses or their supervisors. Or B, the above acts would impair the employee's rights or privileges under existing labor laws. So, if the salary of an employee is diminished, or her rights or her privileges are diminished or lessened because she does not want to give in to the sexual favor being asked for, then there is sexual harassment. Or the above acts would result in an intimidating, hostile, or offensive environment for the employee. What do we mean by this? No? It simply means that the employee is intimidated. No? Yung sumasama yung loob niya, yung umiiyak na siya. There is an intimidation. That's why this makes sexual harassment very dangerous because it is the other way around. Under criminal law, there is the presumption of innocence, but here there may not be a presumption of evidence. There may not be a presumption of innocence. We shall take that up later. So, how is demand, request, or requirement of a sexual favor manifested? Paano mo manalaman na ang isang employer or a supervisor or person who is in a position to ask for sexual favor is requesting for a sexual favor? If there is an invitation, malicious or not, tending to create in the mind of another a scenario of illicitness, scandalous, or amorous situation. That's why it is so dangerous, as I have said earlier, because the burden of proving that the invitation is in good faith is on the part of the person making the invitation. Okay? Here. The existence of sexual harassment is viewed from the perspective of the victim and not from that of the aggressor. This is very important. In determining whether there is sexual harassment in the workplace, it is to be viewed from the perspective or from the emotional reaction of the victim and not from that of the aggressor. No? So what do we mean by that? When you make a sexual harassment or when you ask for sexual favors, you cannot claim that you are doing so in good faith if the other party or the person to whom you extended the invitation did not feel comfortable about it. Let us take the case of PBS RTVM versus Berhel P. Tabasa. In this particular case, K was a contractual employee of PBS RTVM, which is a broadcasting company. Now, Berhel Tabasa is his immediate boss. Berhel P. Tabasa had a fancy with her. Sabi niya, parang anak kita, no? So he did not really ask for any sexual favors. Sabi lang niya, Kay, parang anak kita, tuwing nakikita kita, naaalala ko yung anak ko. Kaya, pwede bang halikan kita, no? So, he kissed her every morning, every time they met. Oh, dito na yung anak ko, no? He kissed her, and then he gave her roses, he gave her chocolates, and then she started telling her green jokes. Linoloko-loko niya siya, no? No, oh, ganda mo naman, oh, tumataba-taba ka na, no? Siguro kailangan mag-exercise ka. He was making some sexual advances already under the guise that he was treating her as her daughter. Kay felt so uncomfortable and she filed a case of sexual harassment against Berhel P. Tabasa. What was the defense of Berhel P. Tabasa? Sabi niya, Sir, sabi niya, wala naman akong masamang intensyon eh. My intention was just to make her happy. I just wanted to amuse her. Nagbibiro lang naman ako yung mga sinasabi kong mga biro, no? Watch out for the jokes. Because sometimes jokes offend people and when it does, it may become harassment. Okay? Because of this, take note, the existence of sexual harassment is viewed from the perspective of the victim and not from that of the aggressor. Kaya kung nagbibigay kayo ng mga jokes doon sa mga katrabahuan ninyo o sa mga boss ninyo o doon sa mga underlings ninyo and you feel that they are no longer comfortable about what you're saying, what you're doing, you better stop. Because if you don't and you continue, you might be charged for sexual harassment. Let me give you another example. In the case of Uy versus Court of Appeals, in this particular case, Mr. Uy was presiding over a board meeting among the corporate officers. And in one instance, when he said a statement, one of the board of directors raised his hand and said, Sir, sabi niya, can you please come again? Sabi niya, can you please come again? And Mr. Uy, who was a humorous guy, said, What? What did you say? You want me to come again? I did not yet come the first time and you want me to come again? Sabi niya, no? And how can I come again under this atmosphere? Sabi niya. So, from the viewpoint of Mr. Uy, he felt that it was just an honest joke. He was just trying to lighten up the moment by giving a green joke among his peers. But the person who heard it did not take fancy on it and he filed a case of sexual harassment. So what was his defense? Sabi niya, biro lang naman yun eh. No? Biro lang naman yun eh. Eh tayong mga Pilipino, mahilig tayong magbiro, di ba? We tell jokes among ourselves and sometimes we go to the extreme and what do we tell? Mahilig tayo sa green jokes. Be careful. Because in telling these green jokes, an innocent comment might offend somebody, and if it does, you might be charged for sexual harassment. And if you are charged for sexual harassment for giving an honest comment, you cannot say that you did so in good faith because of this case. It says the existence of sexual harassment is viewed from the perspective of the victim and not from that of the aggressor. Ano, ninervyos na ba kayo? Nervous ba kayo dahil dito? Kasi I know this for a fact that ang dami-daming mga tao who tells green jokes among themselves, di ba? And then we think that we are not doing anything wrong. But you have to be careful about it because if somebody who is very sensitive will hear it, sasabihin niya, I feel very uncomfortable with what you had been telling me, you might be charged for sexual harassment. And since the existence of sexual harassment is viewed from the perspective of the victim and not from that of the aggressor, it can be very easy for somebody to fabricate and say na ang sinabi nitong taong ito ay very offensive sa akin. And you might be charged for sexual harassment and you might have a criminal record even without you intending to do so. Okay? Because intention in this case is not material since this is a special law. This is a malaprohibitan law which does not need any intent before it can be committed as a crime. Okay. Next slide, please. Okay. So, as I've said earlier, it is not concerned with sex, sexuality, neither is it gender-based. What do we mean by it is not gender-based? No? Regardless of whether two persons belong to the same gender, male or female, or LGBT and male, and vice versa, it can still be committed, or you can still be charged for sexual harassment. I'll give you an example. In the case of Anglo-Eastern Crew Management Philippines versus NLRC, no? A Norwegian ship captain took fancy on a Filipino seaman, and while he was serving him his meal, sinabi niya dito sa Filipino seaman na, I would like you, then this Filipino seaman's contract was about to expire. Mag-expire na in a week. Dadaong na siya. And then the Norwegian captain said na, oh, I want you to perform an oral sex on me, sabi niya. Otherwise, I will not renew your contract. Okay? Sexual harassment or not sexual harassment? You might say, sir, bakit yung Anglo-Eastern Crew Management Philippines ang nademanda? No? Because they were the employment agency. And under OWA rules, if an overseas employment suffers maltreatment from his employer, then he can file a case against his recruiting agency. So that is what happened here. And the defense of Anglo-Eastern Crew Management Philippines was, number one, the Norwegian captain was beyond the jurisdiction of the court, but we will not take up about the jurisdiction. Number two is the same defense as they made in the Gretchen Pulido. Both of them are male, and it was not consummated. Hindi naman nag-oral sex eh. Sabi niya, sinabi lang niya, he merely invited. And the Supreme Court said that there is sexual harassment because sexual harassment is not gender-based. Whether they belong to the same sex or they belong to the same gender, there is sexual harassment. And the fact that it was not consummated, hindi nga ginawa ng Philippine seaman, the fact that there was an invitation, no, we go back to the definition. If there is an invitation, the mere invitation or an advancement of a sexual favor from another already constitutes sexual harassment. Okay? So let's be more specific. How does one commit sexual harassment? Paano ba nangyayari ang sexual harassment? Next slide, please. There are generally 8 specific acts on how sexual harassment is committed in the workplace. And what are these? Number 1, pinching, touching, or brushing the person's body intentionally. Take note, it has to be intentionally. Yung pakurut-kurut ka, no? Yung pa-chancing-chancing ka. That is a form of sexual harassment. But it has to be done intentionally. Because there were instances when accidentally nagkabanggaan sila, that's not sexual harassment because it was not intentionally done. Number 2, sexual comments and green jokes. So this was what I was telling you. Yung uwi case na green jokes na sinabi niya na, how can I come again if I have not yet come the first time? No? So may mga sexual intonation yan. May implication yan. Okay? Sexual comments and green jokes. Number 3, asking about one's sex life. O yung tatanungin mo, no? O how often ba na nagsesex kayo ng husband mo? Or kaya mo pa ba? Can you still do it once a week? Or can you still do it every day? No? That is a sexual harassment. Making a lewd hand or body gesture. I think that's clear, no? Yung ginaganon mo, yung finger, yung binibigay mo yung finger, o kaya yung nag-tiktok ka sa harap nila na ginaganon mo, gyrating or whatever, no? So be careful also of doing TikTok in the workplace because it might be misconstrued as an act of sexual harassment. And if you do that and it is misconstrued as an act of sexual harassment, even if your intention was to entertain, then you might be in trouble. Number 5, kissing or embracing against one's will. Okay. So again, take note, it must be against one's will. Kasi it may happen na nagbe-beso-beso kayo, di ba? You meet each other in the morning, beso-beso, o kumusta na yung gabi mo, no? You embrace each other, that's okay. But once it is against one's will, then that already makes it as a sexual harassment. Number 6, catcalling. O yung ginaganon-ganon mo, no? Yung you call them, ganda-ganda, miss, mga ganon-ganon. Okay? 7, leering or staring maliciously. No? Okay? So how many times have you already undressed a woman by just staring at them? Ganon. So leering or staring maliciously. And number 8, malicious compliment. Okay? Yung sasabihin mo, ang ganda man ng puwit mo, ang laki-laki ng puwit mo, ang sexy mo. Siguro pagka naghubad ka, maganda ka. Ganon, no? So malicious compliment. So pinching, touching, or brushing the person's body intentionally, sexual comments and green jokes, asking about one's sex life, making a lewd hand or body gesture, kissing or embracing against one's will, catcalling, leering or staring maliciously, and malicious compliment. Now, who may be guilty for sexual harassment in the workplace? The following are guilty of sexual harassment in the workplace. First is the perpetrator. And the perpetrator may be any of those we have enumerated earlier. Natatandaan nyo? Yung employer, yung employee, yung mga agent of the employer, the teacher, so forth and so on. Okay. Number 2, any person who directs or induces another to commit any act of sexual harassment or who cooperates in the commission thereof by another without which it would not have been committed. Okay. This is qualified by the phrase, without which it would not have been committed. So kung sinasuggest mo lang, nasabihin mo, ligawan mo nga yan, halikan mo nga yung employee yan, no? But it was not committed, then that is not sexual harassment. But if he did it, because it's qualified by the term, without which it would not have been committed, then you can also be charged for sexual harassment. Then you may ask, Attorney, paano kung hindi naman ikaw ang nagharas? Sinabi mo lang. It does not matter whether you committed directly the act because if you cooperated, then you are a co-conspirator. And under our penal laws, if you are a co-conspirator to an act, even if you did not directly participate, you are equally liable. Okay? Number 3, the employer or head office shall be solidarily liable for damages arising from acts of sexual harassment committed in the workplace if, being informed of such act, no immediate action is taken thereon. Bakit pati yung employer or head office will be held liable for sexual harassment? Because under the law, employers or the head office are mandated to implement policies that will prevent sexual harassment in the workplace. And if they do not do that or they do not punish the perpetrators of sexual harassment, then they are solidarily liable. But take note, the liability of the employer or the head office here is only civil. It's only civil, not criminal. It's different with the perpetrator and any person who directly participates because they may be imprisoned, but the employer is only civilly liable. Ibig sabihin, magbabayad lang siya ng damages. Okay. So, how do you prevent harassment in the workplace? The most practical solution to prevent sexual harassment in the workplace is control your urge. No? Control your urge. Think before you act. Think 10 times, especially now that you know what constitutes sexual harassment. Think before you act. Alam mo na eh. No? Pag ginawa ko pala ito, baka ako ma-charge ng sexual harassment. Huwag na lang. No? It does not lessen your personality or it does not destroy your courage if you do not communicate in the manner of sexual harassment with your co-workers. Because you have to realize that each and every person has a different sensitivity, no? What may be malicious for him, what may not be malicious for you may be malicious for another. And you have to remember the jurisprudence that we have taken, that sexual harassment is to be determined from the viewpoint of the victim, not from your viewpoint. So control your urge, think before you act. Okay, so what are the legal provisions for the protection of workers against sexual harassment? 1. It shall be the duty of the employer or head office of the work-related educational or training environment or institution to prevent or deter the commission of acts of sexual harassment and provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment. Okay. Under the implementing rules and regulations of the Labor Code, it is now mandatory that each and every establishment must have a grievance procedure for the resolution, settlement, or prosecution of sexual harassment acts. If there is none, then they may be fined. And if there is none and sexual harassment is committed in the workplace, then the employer, as we have stated earlier, can be held solidarily liable. Anong ibig sabihin ng solidarily liable, no? As distinguished from jointly liable. Ang joint liability simply means na pagkahalimbawa gumawa ng sexual harassment yung employer, yung isang employer, no? Against a co-employer or an employee against a co-employee. If the liability is joint, kailangan yung victim must collect first from the perpetrator. Pagka walang maibayad yung perpetrator, then that's the only time na pwede niyang habulin yung employer. That is if the liability is joint. But the law provides for a solidary liability. What do we mean by solidary liability? Solidary liability. Ang solidary liability means to say na pagka gumawa ng sexual harassment yung isang employee laban sa isang employee, and there is no procedure, grievance procedure for the resolution, settlement, or prosecution of acts of sexual harassment, then the victim may go immediately against the employer even without going against the perpetrator. That is what is meant by solidary liability. Okay? That's why it becomes necessary, if you are a working institution, that you have to provide for procedures. If you do not know how, you can always ask the assistance of the nearest regional Department of Labor and Employment. Okay? Legal provisions for the protection of workers against sexual harassment. This is what I was saying. Okay? So the employer is mandated by law to create a committee on decorum and investigation of cases on sexual harassment. The committee is composed of one representative each from management, union if any, the employees from the supervisory rank, and from the rank and file employees. Ito yung constitution ng grievance committee against sexual harassment that I mentioned earlier. This is mandatory for all establishments. Okay. So what is the penalty if you commit sexual harassment? The penalty is not less than 1 month, nor more than 6 months imprisonment, or a fine of not less than 10,000 pesos, nor more than 20,000 pesos, or both. No? So sasabihin ninyo, konti lang naman pala, no? 1 month lang naman. No? But take note that this is only for the sexual harassment this only for the sexual harassment charge that is made against an employee or an employer. because this is without prejudice to other criminal cases or other civil cases that may be filed against the perpetrator. Okay? So pwedeng charging ka ng rape. Kung halimbawa ipinasok mo ang solid object on any orifice of the body of an individual. That's rape, no? Kung ipapasok mo yung finger mo sa tainga ng tao o sa ilong niya o sa bunganga niya or any private parts without his consent, that's rape under the new rape law. Huh? Or they may charge you for unjust vexation because the law says it is without prejudice. It means to say, pwede kang filean ng sexual harassment, pwede kang filean pa ng ibang kaso. Okay? So, paano yan? Sasabihin mo, we can no longer enjoy safe sex. We can no longer have a healthy sexual relationship with our workmates or whatever. No, you can. No, you can still have. In the book, The Act of Marriage by Tim and Beverly LaHaye, this is what they said. No, the most thrilling, exciting, and fulfilling experience in the world, if done properly, is the act of sex. God designed it that way. And it is nearly universal for everywhere you go on this planet, Earth. You see the result, children. Okay? But you have to have a control because if you don't and you do it indiscriminately, it might put you in trouble. So control yourselves in the workplace and be safe. You are, after all, there to work and not to take advantage of anyone. Okay? So that ends my lecture for tonight. Thank you, and I hope you learned something from my lecture.
Thank you, Attorney, for that very engaging lecture. It kept me at the edge of my seat. I think we have a lot of things to talk about and we have a lot of questions.